We're happy to have Terry Sanks, who's an IP attorney, that's intellectual property attorney at Busey Sanks, to talk about some of the recent changes in the law. Thank you so much for stopping by.
Thanks for having me today.
Can you talk a little bit about the FTC's ruling on non-compete laws or agreements?
Yeah, in April of this year, the FTC came out with a final rule where they've essentially outlawed all non-compete agreements. What's interesting about it is some states already excluded or prohibited non-compete agreements. One in particular was California. There's been studies done that showed, that concluded the reason you have a Silicon Valley is because they didn't have non-competes. So instead of companies being able to limit where employees moved, it was up to the company to basically incentivize employees to stay. So, and based on that, it created the growth that you saw out there. That's why you have Amazon out there. Well, not Amazon, but you have Apple, you have Facebook, you have Google,
Microsoft.
Twitter's out there. Well, Microsoft is primarily in Seattle, but though they're there as well. But a lot of your startups, a lot of your newer technology companies are all still being developed in Silicon Valley. And one of the underlying bases or reasons for it, they've concluded, is because of having non-competes. So these employees can move from Apple to Google to any of the other high-tech companies without, and the thing that's, what is now being more protected is trade secrets, non-disclosure agreements, so that when these employees move, it's more of a concern or a watch to make sure they're not taking basically the company's jewels with them, but they are able to still take their know-how and what they've developed about themselves to these other companies.
And just, we get asked this often, but for the benefit of the audience, give us a scenario. And what would the difference be if an independent contractor was asked to sign a non-compete? Are independent contractors affected by this law? And also, what are their exceptions to the current rule?
Well, first, the current rule, even though the final rule went into effect in April, it was April 23rd, it's not in effect until August 23rd. Even after it goes into effect, you're probably going to see a few years of litigation before it truly goes into effect. So where it all pans out in the end, we won't know for, I'm guessing, at least a couple years.
Yeah.
Now, as for an independent contractor, typically independent contractors are not under a non-compete to start off with. So I don't think it's going to affect an independent contractor going forward. I mean,
I'm thinking about the developers, and so sometimes your clients will hire a developer to do a site, and would they be bound, or are they exceptions, I wonder, to the rule?
Well, when I write those types of agreements, I'm not really saying you can't compete. I'm
confidentiality.
Saying, yeah, I'm using the confidentiality. I'm saying, okay, this is confidential. You can't now take, or again, you're just doing a development, software development, there's a copyright involved. They're assigning that copyright to the company who's contracted with them. And yes, they've signed off saying they will not, this is confidential to that company. As for, you're right, as for the non-compete, could they still now go out and work for another company and build a similar site? Probably.
Yeah.
But at the same time, that would probably happen even if they weren't using that contractor. I mean, if I am a competitor, you've got a site built, I see your site, I say, oh, I like that, I can still go find someone else, go look at her site, see how it operates, now build me something similar. That's still going to happen.
Yeah. And a lot of this is the question a lot of people have is, did it really make a difference? Because we have these agreements, and sometimes the cost to enforce them, even if there is a rule to protect a client, if it gets breached, many people unfortunately don't have the means to litigate and overcome the rule that was or is.
I agree, and I think right now we're talking really more at the tech level. Let's break it down and say, let's talk about that nurse who might have worked with a practice, a medical practice, and that doctor decides to retire and he sells his practice to a corporate medical group. That corporate medical group can come along and say, here's a non-compete. You can't, now you nurse who've been doing the same process and procedures for say 5 years, 10 years, now that we're in place, we're going to have you sign a non-compete, so you can't compete in the 50-mile square radius of where you are now. Is that fair to that person?
Right.
What are they stopping them from doing? They're really just locking that person into that job, unless they want to say, if it's Orlando, now they have to go to Daytona to work for the next 3 years because of the non-compete. So that's what that rule is doing away with. And so at the same time, now it's putting it on those companies, those employers. They've got to find other ways to incentivize their employees, so that they want to stay with them.
Well, we really appreciate you coming and talking to us a little bit about this, and making people a little more aware of what's at stake and the evolving law with non-competes, and always good to see you.
Likewise.
Thank you. There's more Legal Connections coming up. Stay with us.